Hey y'all, it's Nicole the News Lady, and I'm so excited to have you here. It's the Nicole the News Lady show. I'm a Chicago-based journalist, and I'm sharing the news with you to empower you to pay attention and don't look away because, unfortunately, honey, this is happening. Today, I want to talk about the Supreme Court. But before I get there, I want to go back in time. Picture this, it's 1873, it's 8 years after emancipation. Black folks have the right to vote. They're being elected to Congress and other local and state offices. But then when you look at the plantations that they used to work on, they're barren. The places that gave Southern white Democrats their wealth are completely gone. The 14th and the 15th Amendment have passed. This is the fruit of Reconstruction. But the white Southern Democrats are calling for redemption. The return of white supremacy and the rollback of recently acquired rights that Black folks have been enjoying, thus ending Reconstruction. These were so-called redeemers or Southern white Democrats. Their rallying cry is this: hasn't enough time passed to offer these Negroes these special provisions and protections? Now fast forward to present day. On Wednesday, October 15th, 2025, during the Supreme Court arguments, the conservative majority Supreme Court justices had a similar question. Here's Justice Brett Kavanaugh.
As you know, is that this court's cases in a variety of contexts have said that race-based remedies are permissible for a period of time, sometimes for a long period of time, decades in some cases, but that they should not be indefinite and should have an endpoint. And what exactly do you think the endpoint should be, or how would we know for the intentional use of race to create districts?
So this case is the latest challenge of the Voting Rights Act of 1965, specifically challenging Section 2. I want to remind you, the Voting Rights Act of 1965 is the last vestige of constitutional protection to ensure that voters, no matter their race or ethnicity, have the right to vote. Now, Section 2, as Justice Ketanji Jackson Brown said,
Section 2 is not a remedy in and of itself. It is the mechanism by which the law determines whether a remedy is necessary.
That's absolutely correct.
So it's a law that is just encouraging or requiring a check-in. It's like a tool. It's like a tape measure that we're looking as to whether or not certain circumstances exist. And those circumstances that Congress is worried about is unequal access to electoral opportunity. And Section 2 tells you we have to look for those circumstances, and then the court says, yep, they exist in this situation under Section 2, and so now a remedy is required. And in our case law, we then say, okay, state, it's up to you to figure out what that remedy will be, and maybe that remedy involves race consciousness, maybe it doesn't, whatever. But Section 2 itself is just the measure by which we determine that a remedy is required.
That's absolutely correct.
And so that's why it doesn't need a time limit, because it's not doing any work other than just pointing us to the direction of where we might need to do something.
Now, I want to remind you, it is this key measure of Section 2 that has created Black representation from the Southern Black Belt. Today, those very states like Georgia, Mississippi, Alabama, they represent 43% of only 66 seats of Black folks that are in the United States Congress. Think about that. And so now that we have that, I am excited to bring my guest here. First, can you just introduce yourself, your name, your title, and all of that?
Of course. My name is Aderson Francois. I'm the director of the Civil Rights Clinic and a professor of law at Georgetown University Law Center.
Thank you. So we're here to talk about the Louisiana v. Callais case. If you could just start us off and, what is this case? What's at the heart of it?
Sure. Following the 2020 census, Louisiana withdrew its congressional district, as most states had to do. The plan that they adopted in 2022, and you can call it the 2022 plan, including only one majority minority district out of the state's 6 congressional districts. And a group of African American voters sued because they argued that the plan violated Section 2 of the Voting Rights Act of 1965. Section 2 of the Voting Rights Act requires the state to draw so-called majority minority district when drawing such district is necessary to ensure that minority voters have what the law calls, quote, an equal opportunity, close quote, to participate in the political process and elect a candidate of their choice. And to establish a violation of the equal opportunity standard, minority voters, have to show 3 things that typically are fairly easy to show, particularly in Southern jurisdiction. They have to show that minority people represent a large enough group and are sufficiently geographically compact, sort of packed together in one area, so that if you were to draw a reasonable district, that will constitute a majority. And that minority group is politically cohesive, that they tend to vote in similar fashion. But more importantly, that non-minority voters, mostly white voters, tend to vote themselves historically and present day as a bloc so as to defeat the interests of minority voters. So the plaintiff won the lawsuit in the district court. The Fifth Circuit affirmed, and Louisiana went back to the drawing board and came up with what we can call the 2024 plan. And that plan had a second majority minority district instead of one. So you would have had 2 majority minority districts of the state's 6 congressional districts. But this time
And
around,
Louisiana, the Black voters are a third of the population, so it's kind of proportion, correct?
roughly, because typically speaking, the population of Louisiana has always hovered between 30 to 33%. So that a group of non-Black plaintiffs this time around challenged the plan because they said that the state used race in such an obvious factor that it really violated the equal opportunity standard, and a different court ruled for the white plaintiffs and threw out the plan. Eventually, the case went up to the Supreme Court. They heard oral argument, but the court did not decide the case at first last term, except it basically sent it back for re-argument. And this time around, the court phrased the case in a different question than the parties themselves had never asked. And the question was whether or not intentionally creating a majority minority district using race violates the Equal Protection Clause of the 14th Amendment. And that's a big problem. And the reason why it's a big problem is that ever since at least Washington versus Davis in 1976, the court said that the 14th Amendment only prohibits intentional discrimination. It doesn't prohibit discrimination, any action by the government that has a disparate racial impact, but wasn't intended to have such an impact. But at the same time, the court also held in 76 that Congress, if it wanted to, could pass laws that prohibits disparate impact, even though the 14th Amendment itself doesn't require that, right? So the assumption up until now is that when Congress allowed majority minority district to take place, essentially when you were to draw such a district, drawing such a district would basically pass constitutional muster, because you would say, look, I have a compelling state interest because the Voting Rights Act requires me to do this, and I've done it in a narrow fashion. What's happening right now is that when the court said whether or not drawing these districts is inconsistent with the 14th Amendment, what the court is really asking us to consider is whether or not, disparate impact analysis, which is what this is about, namely a law that presumably is neutral but has a disparate impact on Black people, cannot survive constitutional scrutiny. And if that happens, the consequences are twofold. The first is that a fairly significant number of districts now that are represented by African American representatives in Congress are in serious danger,
Mm.
right? So essentially, you may have a situation in 2, 3, or 4 years' time where the Congressional Black Caucus is reduced by as many as between 20 to 24 seats, which is significant. The second thing is that if you basically say that disparate impact analysis is inconsistent with the 14th Amendment when it comes to the Voting Rights Act, there is no reason to suppose why you cannot say the same thing for all other civil rights laws that use disparate impact analysis. And that is a serious problem.
Yeah.
Because, nowadays it is unlikely that you can really show that government action is discriminatory because you can prove it was done intentionally. Only somebody who's not very bright would say that's what they're doing. Instead, you may wish to discriminate against Black people, but you simply disguise that through some supposedly officially neutral action or neutral law. And you used to be able to challenge those actions through disparate impact. The court may actually be closing the door on that. And that would have a radical shift in the way that we think about civil rights laws in this country.
Yeah, because some of those unintentional ways is like zip code, population, income, and things like that. Those are ways that you could say we didn't intentionally do it, but when Black folks live here or Latinos live there, and then you try to hoard resources within or outside of those areas, and you say, "Hey,
Exactly.
we were just going by zip code."
Or take, for example, government entities, government agencies, right, who for years closed their doors to minority people or to women. And as a result, those government entities have on their face various laws that appear to be neutral because maybe they are based on seniority, and seniority is neutral. But again, because these opportunities were closed to minorities for so long, whenever you have a sort of similarly neutral seniority principle, the folks are going to be the most affected by it are going to be minority people who didn't have the chance to develop that seniority because those doors were closed for them. But on its face, the principle is neutral, right?
Mm-hmm.
So what you're saying is that if you prevent that government agency from taking remedial action by saying we are going to affirmatively do something that would correct for the disparate impact that seniority rules have on Black people, right? Well, the court is saying, well, that is inconsistent with the 14th Amendment that requires you not to take race into account at all when you make these decisions. So unless you can show us right now that those seniority principles were intentionally enacted to deny opportunities to Black people, we're not going to allow you to correct for them, which of course you're not going to be able to do most likely, particularly in this day and age.
So that kind of leads me to the spirit of the law.
Mm-hmm.
What the word zeitgeist is going around, but when we think about the collective consciousness within government across the country in the 1950s, 60s, the environment that brought us to this point to create the Voting Rights Act, what was different about that time then where institutions, government officials, even I read LBJ's remarks when they signed the Voting Rights Act, it was so clear that discrimination existed, that the Negro had a hard pass for the last 200, 300 years. And now we've gotten to this point where we can't say Black, we can't say this, we can't say that. How do we get to this point? Because I feel like, there was Jim Crow, civil rights, all of that that got us to this point where there was these reckonings, but now we're like, no, that doesn't exist anymore. Is it that racism has been so entrenched within our institutions where you could say, hey, they've engineered that way. We're like, hey, we didn't intentionally do this, just baked into it. And it's hard to refute it. Or what is it? Like, what changed where we couldn't really call a thing a thing?
Well, a couple of things to say in response to your question, because I think what you're raising is a very important point. I know that whenever we talked about the Voting Rights Act, particularly with respect to this case, whenever the news was reported, one of those sort of iconic pictures that is used is Johnson signing it, which I think is important. But it helps to remember that the Voting Rights Act has been, over time, renewed and amended on a number of occasions. And the last significant such renewal was done under President Bush. So up until recently, particularly with respect to voting rights, the idea that you had to take remedial actions to make sure that Congress was representative of the people of the United States was a non-controversial idea that was supported both by Republicans as well as Democrats. So even if you think of Shelby County, where the court overruled Section 5 of the Voting Rights Act, the preclusions provision, the last time the Voting Rights Act was renewed in Congress, I think it was voted in the Senate by something like 99-1, including reauthorization of Section 5, including the fact that, for example, the idea that Section 2 prohibits disparate impact was enacted in 1982. Right? So it's important to understand that this notion now that Republicans and conservatives are adamant against enforcement of the Voting Rights Act in virtually of its aspect, it's a recent phenomenon, which I think it's sort of helpful to understand how we got here. So that's the first thing. The second thing to mention is that if you were to listen to the argument very carefully yesterday before the Supreme Court, right? The overall theme of the argument was that how much longer are we going to do this? How much longer must you give this sort of special consideration, special treatment to Black people, right? The Civil War has been over for a very, very long time. The 13th Amendment was enacted, right? And even if you go back to the modern civil rights movement, we don't live in the 60s anymore, right? This is a modern time. So therefore, at some point, you have to reach the state where you say, okay, enough is enough. We can't keep doing this special thing. And my answer to this is that the same argument was made quite literally, and I say that with no exaggeration, barely 2 months after the Civil War ended. The very, very first time Congress considered the so-called Freedmen Bureau to at least provide some measure of relief for 5 million people who used to be considered property were now free. 5 million people whose mothers and fathers, daughters and sons, brothers and sisters had been sold away to distant places and they couldn't find them. So people were putting advertisements in newspapers saying, quote unquote, help me find my people. So I'm really mentioning the fact that it was barely months after the war ended. The argument that was made against these civil rights laws, right, in 1866, 1867, 1868, 1870, 1875 was, how much longer are we going to do this? We basically freed people, right?
Isn't that enough?
Isn't exactly. But and when you keep doing this, the court decided a case back in 1883 called the Civil Rights Cases. And the law was about prohibiting racial discrimination in places of public accommodation. including public schools, and the laws about prohibiting that discrimination, whether it was done by government actors or private actors. The court overruled that law. And bear in mind, please, that it was 1883, barely 20 years after the end of the war. And the court ends the opinion by saying, there comes a time, okay, when Black people have to stand on their own 2 feet and stop expecting special treatment on the part of the government. They have to go back to their home states and be willing to stand as, quote, mere citizens rather than, quote, special favorites of the laws. My question to you then, if barely 6 months after the end of the war, barely 5 years after the end of the war, you're already saying to Black people, come on, enough time has gone by. So how am I supposed to take it seriously now that you're saying now that, oh, come on, enough time has gone by? The argument that enough time has gone by has always been a refuge for those who want to recreate white supremacy. It's always been the case. So I'll end with this last example. The very first set of Black civil rights legislation that was designed to provide some economic welfare to newly enslaved people, people who had worked all their lives for nothing, people whose fathers and mothers and grandmothers had worked all their lives for nothing. That first piece of welfare legislation was blocked in Congress because the argument was, number one, if you do that, you're gonna make them dependent on you. Number two, how is it fair to do that for them and not do that for the white orphan and widows whose sons and fathers were killed during the war in the Confederate Army? So no, I don't take the hasn't time changed enough very seriously. I think it's the refuge of those who simply want to make sure to go back to the status quo of white supremacy.
Wow. Yeah, it's so there's been this war that's never really ended. That's essentially what you're saying. It's been this war, it's been this argument, and so now it's kind of the confluence of a perfect storm, because even though we're talking about voting rights right now, there's a conversation around Title VI and Title IX on the school and higher education level. So it's saying that all those protections
are at play.
are at play.
Those protections are at play. And there's one thing I should mention, because I found that to be a sort of bitter irony. There's a sort of dark poetical arc to the fact that if the court decides the case, as I imagine it will, that which essentially will strike a very dangerous blow to civil rights law, that case should have come out of Louisiana. And the reason why I'm saying this is because, as you probably know, Louisiana in many ways is where Reconstruction began. And it began in Louisiana in a very deliberate fashion. The radical Republicans and Black freedom fighters who were interested in Reconstruction chose Louisiana as a sort of testing ground because Louisiana had a very large population of freed and educated Black and mixed race folks. And the notion was that if you could start Reconstruction in Louisiana, you could actually use it to prove to people that this sort of multiracial democratic government could exist and succeed and serve as a model for the rest of the country. So in 1868, right, following the Civil War, Louisiana held a new constitutional convention that wrote a new constitution. That convention featured 49 Black delegates and 49 white delegates, 50-50. They drafted a new constitution that, among other things, granted full political and civil rights to Black people. It created one of the first system of non-segregated public schools in the country. It eliminated the requirement for owning property as a condition for holding office, and it expanded the rights of women. It was one of the most advanced constitutions a state had ever adopted. The very first laws that the multiracial government in Louisiana enacted were meant to serve people. And one of them was about the fact that there had been an epidemic of cholera in New Orleans every 10 years because butchers who owned property near the river would throw their waste into the river. It would flow downhill and poison people. And they moved the butchers out of the river. It triggered a very famous case called the slaughterhouse cases. But if Reconstruction is where if Louisiana is where Reconstruction began, it's also where it ended. For example, think of the Colfax massacre in Louisiana, where after the 1876 election, where whites sort of refused to accept the slate of liberal Republicans who had been elected, and a group of white militiamen had gathered at the courthouse to defend them, and the white mob stormed the courthouse, burned it down, and killed a whole bunch of them. And the Supreme Court refused to hold them accountable for that. That was, the so-called Cushion case. And last but not least, Louisiana is where the court constitutionalized Jim Crow in Callais versus Ferguson. So Reconstruction began in Louisiana. It explicitly ended in Louisiana, and Jim Crow was constitutionalized in Louisiana. So I think if it turns out to be that the court kills disparate impact analysis and the Voting Rights Act out of Calais, maybe there is almost like a dark poetic justice in there doing the one place where Reconstruction began and ended. I don't take any joy in that, but I mean the symbolism
Yeah,
of
it's uncanny.
is being extraordinary. And what I found most frustrating about this, particularly listening to the argument, is how completely ahistorical that the justices are or pretend to be. That somehow we pretend as if we're deciding these cases as if history began 30 years ago.
Mhm. Yeah.
But here's the thing that the court doesn't consider, right? The very, very first Black representative in Congress elected in Louisiana since Reconstruction was elected in 1992. Representative Clyburn, who is one of the most powerful Black representatives in Congress out of South Carolina, he was the very first Black person to be elected in Congress from South Carolina since Reconstruction. If you can go down if you want to in virtually all of these states, particularly Black belt states, and you look at the Congressional Black Caucus, and what you will see is that many of them are either the first or the second Black person to be elected from their states since Reconstruction. So how exactly then are you going to lecture us about maybe there is no need for this anymore because special district? Here's what I think we need to understand and be honest about it. Black people in this country, historically by necessity, have always known how to vote for non-white candidates because they always have, often out of no choice. The only group that has still not yet learned how to vote against across racial lines are white folks. White voters, in the main, still as a bloc, do not vote for Black candidates. And no, Barack Obama is not the exception that this proves the rule. Go by congressional districts Black voters have long known how to cross the racial line and vote for white candidates. White voters still haven't learned how to do that. That's why majority minority districts exist.
So you kind of hinted at this already. I know the New York Times, they did a kind of what Louisiana would look like now versus if this was overturned? What would be the process? Could we anticipate new maps being withdrawn in the next year before midterms? Will we have to wait to the 2030 census? Um,
No, I think we're in a very dangerous position because normally I would say yes, you would be waiting for the census, but as you already know, at the behest of President Trump, states are not doing redistricting mid mid census, right? So Texas has done it, Indiana is doing it, a bunch of states are doing it. So think about it this way: you and I know that majority minority districts are Democratic districts. If now states are under no obligation to draw them, none whatsoever, if they essentially say we're going to adopt a new plan, and the new plan that we're adopting is simply because we want to maximize partisan Republican representation, which, by the way, the court has said is not unconstitutional. The court has said it's fine to draw a map if the point of drawing the map is to maximize your advantage to one political party, so long as the map is not too crazy gerrymandered in terms of the way it draws the lines. But the court has said that's fine. So if
partisan mapping is map drawing is okay. That's what you're saying?
partisan mapping is not unlawful, so long as the map is not gerrymandered in the way that the lines are drawn as to be too bizarre. So there is nothing illegal necessarily, as far as the court is concerned, for a legislature to draw a map that is designed to maximize partisan advantage. Number one. Number two, Trump has basically told the states that it wants Republican states to basically do redrawing of those maps, not after the census, but right now. So if the court were to say that states are under no obligation to draw these minority majority districts, what do you suppose would be the incentive for many of these states where you have a Republican legislature and a Republican governor not to withdraw their maps? There is no incentive for them. In fact, they have every incentive to withdraw the map. So, the fear that folks have is that you're going to decimate the Congressional Black Caucus. Is not sort of panic or historical fear. It's a very real possibility.
Sorry, go ahead.
If Louisiana doesn't have to draw a majority district, I don't know why they would draw a map that even has one. Why would they?
Yeah.
All they have to say is that the map that we drew did not take this into account. It wasn't intended to discriminate against any person. We simply drew a map because we wanted to maximize Republican advantage, and there is no law that says we can't. Neutral principle. You can go back and say, well, that map has a disparate impact on Black people because that's out the window now.
That's out the window now.
Yeah.
And then there's also, we talk about congressional representation, but this also will impact state and local as well.
Yes, absolutely. Because the Voting Rights Act is not merely about state congressional representation. It's about the Voting Rights Act affect not just congressional representation, but state representation, even down to the local representation. But
yeah. Where do we go from here? I mean, I'm just thinking, it seems like if this is to happen across the South, especially, it seems that we'll have to find, and then they prop up candidates that don't identify as Black or otherwise. What could that do to?
Couple of things, right? The first is that even if the court decides to say that majority minority districts that are drawn specifically with respect to race are unconstitutional, there is no reason why we shouldn't keep continuing challenging those new maps. We can't use disparate impact anymore. but then we'd have to challenge them on the basis that these maps were done with intentional racial animus in mind. It's a very hard thing to prove. It's a hard hill to climb, but we cannot simply accept these maps. So and I know there's going to be a challenge to these maps. I know folks like LDF are going to do it. So that's the first step. The second step is to sort of understand something that folks always try to explain, but many of us forget, that the elections are always about, at the end of the day, the Supreme Court. The reason we're in this position that we are right now is because of the 6-3 majority. Right? And we have, even though that 6-3 majority we may have to live with for a while, it seems to me that every election from this point on, we have to treat both, not just presidential election in terms of who appoints these justices, but also the Senate that confirms them, right? That the idea of who's going to be on the court, who's going to get to appoint, who's going to get to confirm the person, right, is always one of the top 5 issues in any campaign. Okay? Because without this 6-3 court, we would not be in this position. Okay? And it's going to take a while. It's going to take a while. I don't want to basically sound pessimistic. I would just want to say that by the time you hit maybe 1878, virtually every single former Confederate state had been so-called redeemed. They called themselves redeemers, which in fact was simply the idea that every single southern state had a process by which the multiracial democracies were kicked out. White, conservative, Confederate Democrats were back in power. The class of Black representatives in Congress that had been elected in Congress got kicked out of office. You had the Black Codes, and then what followed was Jim Crow. Black political power went into exile for nearly 100 years, which I think most of us forget. And we didn't return back from exile in 1965, when the Civil Rights Act was enacted in 64 and voting rights in 65. It actually takes longer than that. We didn't come out of exile since Reconstruction until probably around 1985, 1990.
Wow.
So we have to be prepared for the possibility that Black political power may, in fact, go into exile again for a time. I only hope right now that we have to fight for that it's not going to be as long. I would love to say that there is an immediate solution to the problem. But you and I both know that the vast majority of Black representatives in Congress, a significant number of them, right, come out of the Black Belt. We know that.
Mm-hmm.
And the reason why they come out of the Black Belt is because the Black Belt is where the vast majority of Black people in this country still live. The Black Belt also happens to trace perfectly where the vast majority of Black people in this country were enslaved. Those Black Belt districts are what's at stake. And if you eliminate them, you can't get them back very easily.
You just have to prop up those candidates.
Yes.
Northern Black people in the North will have to be more intentional about supporting Southern candidates.
Absolutely. Absolutely. It is an extraordinary moment that we're facing, right? Because I know you asked me, how did we get here? And I don't think I have an answer for you. But we are facing an extraordinary moment that sometimes we talk about the fact that the experience of Black people in this country has been generally one of progress followed by intense backlash. Right? And sometimes you think about it almost in sort of abstract terms, or the backlash that you experience seems to be relatively minor. And I think what we have to begin to sort of, and I suspect this is what your work is beginning to do for the community, is that we have to wrap our heads around the reality that we are truly in a redemption moment. The so-called redeemers were people who simply could not accept the idea that we could live free and equal in a multiracial democracy, and they succeeded for almost 100 years. This is not the Robert Court. This is the Redeemer Court. This is not a conservative administration. This is the Redeemer administration. And lest folks think I'm exaggerating, the Times published an article yesterday that talked about that the administration is considering a plan to eliminate the country's refugee program, to replace it with a program that prioritizes white South Africans and white Europeans and English-speaking people to come to this country. That's how serious folks are. We are in the midst of a new Redeemer movement. We are facing a new Redeemer Court.
What a wonderful conversation. I cannot wait for an opportunity to bring him back to the show. But I want to go back to a point that he mentioned. Black political power in exile. So once he said that, I got a little digging. I'm a journalist, so I want to fact check. And I'm just curious. I'm naturally curious. And I went to the house.gov website, and you can do this at home as well. And when I looked, I found that from the 56th Congress, which was 1899 to 1901, all the way to the 71st Congress, which was 1929 to 1931, there was absolutely no Black representation in Congress. None. Think about that. I also want to overlay some key events that happened during that period from 1899 to 1931. You had mass race riots from Chicago on down to Atlanta. You had mass lynchings. And then you also had Jim Crow laws that were spreading like wildfire across the South. Black political power in exile. The things we read about in the history books, it seems like our greatest nightmare has come to be in real life. This is what's at stake with this challenge. So I'll leave you with this. Janae Nelson, she's the president of the NAACP Legal Defense Fund. She also made the arguments in the Louisiana v. Callais case in October. Here's a very sobering picture that she painted for us, those listening, and the justices about what's at stake if we strike down Section 2 of the Voting Rights Act of 1965. Take a listen.
Ms. Nelson, were Section 2 to cease to operate in the way that you just described to prevent vote dilution in districting, what could happen? What would the results on the ground be?
I think the results would be pretty catastrophic. If we take Louisiana as one example, every congressional member who is Black was elected from a VRA opportunity district. We only have the diversity that we see across the South, for example, because of litigation that forced the creation of opportunity districts under the Voting Rights Act. Every justice in Louisiana has been elected through a VRA opportunity district, and nearly all legislative representatives have been elected on those same districts. So Louisiana alone is an example of how important it is to have Section 2 continue to be enforced to create these opportunities. We also know that after majority-minority districts have been created, they often no longer need the same population to continue to provide an equally open electoral process for minority voters. So it is an intervention that has been crucial to diversifying leadership and providing an ability of minority voters to have an equal opportunity to participate in the process. But it also isn't a permanent remedy. It corrects itself over time, and it's only triggered when those extreme conditions exist.
And there we have it. This is what's at stake. Representation, diversity, interest, protection, being seen. Imagine that no longer being a thing. So I want to thank y'all so much for listening. Be sure to like, be sure to subscribe to the channel so you get updates. I also want you to share this with someone who you think might be interested. You can skip through it or whatever. And be sure to comment. And I'll see y'all next week.